Next up is Nita Farahany, who at Vanderbilt, who, with an interdisciplinary background of genetics and biology, philosophy of biology, philosophy of law, extraordinary combination of things, is working in the area at the intersection of criminal law, genetics, and neuroscience and philosophy. She has a volume coming out that was edited called Genes and Justice, the Impact of Behavioral Genetics and Neuroscience on Criminal Law. Lisa.
Thank you. Thank you, Roger, and thanks to all of you for what has been an incredibly interesting conversation over the past couple of days. I have particularly enjoyed each of the different approaches to science and the integration of each of the different areas. And I'm excited to talk to you today about the use of neuroscience in the law. And my area is looking at the intersection of science, philosophy, and law. What I'm going to talk to you about today is my candle. So I'm starting with my candle because it's what unifies my talk a bit. So my candle is that the neuroscientific community and the behavioral scientific community needs to get involved in policymaking. And I tell you that at the outset because I'm going to give you the examples of where they have not yet gotten involved and where they need to get involved because the science is already being introduced into the legal arena despite the fact that the science isn't really ready to be introduced into the legal arena. So it's already being used, and it's being used without the input of the scientist. And the scientists have the opportunity right now to stop and to say, look, the science isn't ready. The science doesn't say what you think it says. And yet they have stepped back and said, no, we're not interested in doing so. Okay, so the first such example is the very specific application of the use of neuroscience and behavioral genetics in criminal cases. So you've heard about that a little bit already from both Walter and from Amanda, but I'm going to give you some of the specific examples, not at the prediction level, but in specific cases. And one such case I was involved in was the case of Jeffrey Landrigan. So I tried to get involved in, I should say. So the case of Jeffrey Landrigan is a case in which an individual committed a number of violent acts of murder. And on appeal, so he was given the death sentence, and on appeal, he claimed ineffective assistance of counsel. And his claim for ineffective assistance of counsel is there wasn't mitigating evidence introduced on my behalf. Now, why wasn't there mitigating evidence introduced on his behalf? Because he said, I'm not interested in having any mitigating evidence introduced on my behalf. He refused to cooperate with his trial counsel on having any evidence introduced on his behalf. But a new theory had been developed in the interim. The theory was a biological predisposition to violence. And his family had a long history of violence. All of the men in his family had been very violent. They had committed a number of violent criminal acts. And he said, if somebody had told me about that, I would have cooperated. I would have allowed that evidence to be introduced on my behalf. And so therefore, it was ineffective assistance of counsel for failure to introduce a biological predisposition to violence. Well, he failed at the district court level. It went up to the Ninth Circuit Court of Appeals. And the Ninth Circuit first, on a three-judge panel, said, well, really, that evidence was just as likely to be used against you as to be used for you, right? So they said, that's not really mitigating evidence, right? A predisposition to violence could have just shown that you were a remorseless killer and that you came from a long line of remorseless killers, right? So why would we be interested in that? Why would the jury be interested in that? Well, there's this thing about capital cases where you have to be able to be allowed to introduce that kind of evidence on your behalf. Even if it might have aggravating potential, it might also have mitigating potential. It might speak to your individual culpability or blameworthiness. So the Ninth Circuit heard the case en banc. That means all of them heard it together. Well, not all of them because it's the Ninth Circuit, but normally all of them hear it together. And en banc, they decided that that wasn't the right decision. Okay, so they said that's not okay. He should have been able to introduce that evidence on his behalf. It went up to the United States Supreme Court. And the United States Supreme Court granted cert on the question of whether a genetic predisposition to violence is mitigating evidence. This is just a couple of years ago. That's huge. Is a genetic predisposition to violence was a question before the United States Supreme Court. Do the scientists know the answer to that question? Is there a genetic predisposition to violence? Right, so what did I do? I contacted the Behavioral Genetics Association, the National Association of Human Genetics, every organization that I could think of, and said I would like to file, along with another lawyer, an amicus brief, neither in support of the petitioner nor in support of the respondent, a true amicus brief, okay, which means a friend of the court petition, to inform the court of what the science is, right? Because nobody was talking about what the science said. Everybody was debating about whether or not a genetic predisposition to violence is mitigating evidence in the constitutional issue. Somebody needs to talk about what the state of the science is. And you know what the scientists said? The scientists all said no, every one of them. And I'll give you a quote from one of them. "We do not feel the current data is sufficient to comment on the heritability of violent behavior and or genomic variation that may predispose to such." Yes, exactly, I agree. I said, so let's tell the court that, right? They said, no, we don't want to get involved in policy. We don't want the court or the media to think that we're commenting on such things. Who's going to, right? If the scientists aren't giving the opinion, if the scientists aren't giving the state of the scientists, who is going to give the state of the science? The lawyers? Happily, I have somewhat of a scientific background. But how many lawyers do you think have a scientific background? Not that many. And mine's outdated. I mean, terrific that I have a scientific background, but I don't do scientific research anymore. And it would be helpful to have the scientific community actually comment. All right, that's in the early phase, right? That's in the stuff we actually know about.